Thank you for joining Health and Safety Chapter 2. This is talking about legislation. Now, this is not exhaustive. We had covered some of this information in class, in particular the Occupational Health and Safety Act and the Code, the Human Rights Code of Ontario. So what are we going to cover here? We're going to identify 3 health and safety rights granted to workers in Canada. We're going to describe the regulatory framework around occupational health and safety, outline the duties of the major stakeholders, such as employers, Joint Health and Safety Committee, and workers under this legislation. And we're going to discuss the nature and the limits placed on work refusals and work stoppages. In addition to this, describing the structure and the role of Joint Health and Safety Committee members and reps. It's based on the size of your company. Discussing WHMIS 2015, which is Workplace Hazardous Material Information System. That's what the acronym is, as it applies to hazards in the workplace in relation to hazardous materials, chemicals, and think of also asbestos. It doesn't have to be liquid form. Explain how occupational health and safety fits into the criminal code, and express how environmental and transportation of dangerous goods legislation interacts with occupational health and safety concerns, particularly the transportation of hazardous materials. It's not just trucks, but also railroad, boat, and plane, and car. Approximately what percentage of workers are regulated by Occupational Health and Safety Act? Well, first thing you have to ask yourself is who is covered under the occupational health and safety legislation. In Ontario, you would, if you're an Ontario employer and you're not federally bound, which means you're not, let's say, an airline, you are not a bank, you would follow under the Ontario Occupational Health and Safety Act. However, if you are a airline like Air Canada, or you are a bank, let's say like Royal Bank, you would fall under federal legislation. So in this scenario, it is 90%. The 10% would follow under the federal legislation. And look up the difference between federally regulated, but also federal organizations. Things like also organizations like working for CBC Radio and television, you would be under federal. This opening vignette, creative sentences for occupational health and safety violations. Well, it's not just the organization that pays fines to the government if they are convicted of occupational health and safety violations. It's also the people who work for these organizations, like management, board of directors. Some jurisdictions allow for creative sentences in addition to lieu of fines, so jail time. In addition to a fine, a Nova Scotia company found guilty of occupational health and safety violations were required to make public presentations. So that's public shaming. Consider other types of possible creative sentencing options that are beyond the scope of this. So the law, the Act. When I talk about the Act in this course, I'm referring to the Occupational Health and Safety Act. Be it federal, provincial, territorial law, it constitutes basic regulatory mechanism for occupational health and safety. We went over the Occupational Health and Safety Act. We went over in class section 25, 26, 27, and 9. And we also talked about competent managers. Regulations, they can be specific. They explain how general intent of the Act will be applied in specific circumstances. There are sections in the Act that are applicable just to construction. Guidelines and policies. These are more specific rules that are not legally enforceable unless referred to in a regulation or act. So think of your own company guidelines or standard operating procedures or policies. They are not necessarily legally enforceable. The government enforces Ministry of Labor, who inspects, and they also oversee the Act, the Occupational Health and Safety Act, and its regulations. So what are standards and codes? These provide practical guides on the implementation, so that pragmatic aspect, rolling up the sleeves and get the job done in relation to health and safety practices. These are often established by agencies such as CSA or ILO. So think of if you look up your laptop right now or any electrical plug, does it have the CSA stamp on it? Has a little circle, and you'll see CSA. So is it CSA approved? The scope of OH&S legislation. All legislation includes the following elements: an act, in this case it's the act, powers of enforcement. So Ministry of Labor inspectors can come in with or without notice, and you are in violation, they can fine, as well as jail time for individuals depending on the seriousness of the matter. The right of workers to refuse to do any unsafe work, protection of workers from reprisal for filing a or refusing to do any unsafe work. So they cannot be punished, they cannot be uh, fired from the employer, they can't be, on their performance review, docked any points or so understand you have this right. You do not have to work unsafely. Duties and responsibilities assigned to employers and others. So Section 25 for the Occupational Health and Safety Act for Ontario will be your best friend here. Due diligence, 25(2)(h). So Occupational Health and Safety legislation in Canada. I know this is relatively small. I'm not asking you to memorize all of this. I think what's important here is Ontario. I will definitely be covering the Occupational Health and Safety Act. I will touch on some of these other briefly. And looking at the government agency responsible, Ministry of Labor, MOLE, talked about this week 1, week 2, and the Occupational Health and Safety Branch. Now, BC, British Columbia, has occupational health and safety regulations. Their government agency is WorkSafe BC. They have some really great videos, really great material. Even though you may not be working in BC, I think there's some value here because there are some areas that I feel that they exceed in. But understand if you're going to be a Canada-wide HR manager or health and safety manager, you then do definitely need to know all of the legislation for all of the provinces and territories. And if you're federally bound, you'll have to know the Canada Labor Code regulations under Part 2. The government agencies that you need to, that oversee it from federal, if you work for Air Canada, you work for CN Rail, you work for CBC, radio, television, banks, Royal Bank, you'll fall under these agencies of Workplace Safety, the Labor Program, Employment and Social Development Canada, and Government of Canada. But if you are a nationwide, let's say, health and safety manager, and it does not fall under federal, then you need to know all of the different legislation and government agencies. So Occupational Health and Safety Acts, they set the standard, but the minimum standards of occupational health and safety within each jurisdiction. I firmly believe we can exceed it. We can always do better. If another province is doing better than us in certain areas, why not adopt it? Set boundaries for application of each act, noting any exclusions. Outline mandatory components of occupational health and safety programming within its jurisdiction. And you have to know the jurisdiction that you're in. Also articulate the duties for the major stakeholders. So managers need to understand their rights and responsibilities. Workers need to know their rights and responsibilities, as well as board of directors, as well as joint health and safety committee members, and partner with the union as well. They have great experts there. We did this in class. I want to continue this theme because it's part of your discussion board number 1, assessment. Stakeholder duties and responsibilities for employers. The general duty is to follow the Act, to be in compliance of the Act. And the biggest one in terms of the employer's general duty provision is under Section 25(2)H of the Occupational Health and Safety Act for Ontario. This due diligence aspect is where the employer needs to take every reasonable precaution to ensure the safety of the workers. And workers don't have to be full-time. They could be part-time. It does not stipulate that you are full-time. And I invite you to exceed that limit of even make it safe for consultants, contractors, make it safe for everyone. So what is prescribed duty? It is a particular duty to be undertaken because of the health and safety regulation. So Section 25 is your best friend here for employers. Please review it. And we'll cover it pretty much every week anyway. General employer duties to take this every reasonable precaution to ensure employee safety. Also, which is due diligence, 25(2)H. Appoint a competent supervisor. Provide information on medical emergency, but also inform supervisors and workers of any possible hazards. Also, the need to post this 1, 2, 3, 4 poster, post the Occupational Health and Safety Act in the workplace. And if you have an intranet or ShareBox, a SharePoint or Dropbox or something on the internet that you share, you should also have the link to that as well. This is in the course outline. So I gave you the Occupational Health and Safety Act's direct link, and we'll be using that pretty much every week. Prepare and maintain health and safety policies and review them annually. But also review it if there's changes to legislation. If there are changes to the Occupational Health and Safety Act, then you need to change your policies. You also need to communicate it, train, and assess people for their knowledge. Prepare policies regarding workplace violence and harassment and sexual harassment. Does your company believe in a zero tolerance policy? This has to be communicated to employees, management, and you have to make sure that it's constant reminders on this. When we talk about stakeholder duties and responsibility when it comes to contractors, a constructor or primary contractor rather oversees the construction of a project and is ultimately responsible for the health and safety of all involved workers. Similar responsibilities to those outlined for employers. 2009, December 24th, there were fatalities. There were also near misses. That means they almost died. 2 people almost died. People did die, but then 2 people suffered post-traumatic stress disorder. Also some physical injuries. It affects families, community, co-workers. Think of the person that has to inform the family of the deaths that did occur. The manager was fined, plus received 3.5-year sentence. This is a new precedent because it's the longest sentence ever. This is a link to the construction company that was also fined. So the manager was fined and jail time, but also the construction company was fined over its fatal scaffolding collapse. So here's one from National Post, and here's another link as well from CBC. Stakeholder duties and responsibilities. Supervisor. Remember, employers have to hire a competent person. That is a supervisor. Supervisor under the Act should be a competent person. Anyone who has charge of a workplace and authority over a worker. The Act may include a general duty provision for supervisors to ensure the health and safety of workers under their supervision. This prescribed duties include ensuring workers comply with the Act and the regulations, ensure workers use personal protective equipment properly, wear, provide it to the workers, but ensure that they wear it and they use it properly. If there are safety devices on, let's say, a saw, making sure that these devices are used properly, guards are not removed from the saw. Also clothing. Think about the pandemic and the nurses that had to be gowned. Also, if you handle asbestos, you need to wear a hazmat suit. You have to wear a proper mask that's fitted, special filters for asbestos, and advising workers of possible hazards. And we'll talk more about hazards on the road. Now we're going to talk about workers. Stakeholder duties and responsibilities for the workers. What are your duties as workers? We're all workers, right? Until we become supervisors and managers, to take reasonable precautions to ensure one's own safety, but also that of your colleagues, your peers, your co-workers, those of others. Comply with the Occupational Health and Safety Act, its regulations and policies. Properly use safety equipment that's provided. Again, do not make changes to equipment by removing guards off, let's say, saws, to use the equipment safely. Report hazards when they happen, such as defective equipment to a supervisor, and report any contraventions of the Act or regulations. Your first person you should be going to is supervisor. Inform the steward. If it's a first aid situation, then you have to follow policies. Required by law are joint health and safety committees. These are required by law in most jurisdictions, but not all. There are special provisions for committees to be created, and it's usually based on the size of your organization. If it is a very small organization of, let's say, comprised of 5 employees, then all you will need is you won't need the committee. I recommend having that representative. If your organization does plan to grow to 20, 30, or 40, that's when you want to think about having that committee. Definitely there is a limit. So if you have, let's say, 100 employees, then you have to have a committee. You would have 2 worker representatives of your committee and 2 management. I always like to exceed it because people go on vacation. They may be sick themselves. They can't attend the meeting because of work or other reasons, family commitments. Have more on the worker side. Have, 4 representatives. I know you don't need to, but try to have more workers than what's required. Try to exceed the law. Help enact this internal responsibility system. Provide non-adversarial atmosphere in which both labor, union, and management can work together, collaborate, be a bridge to work for a healthier workplace. The Joint Health and Safety Committee also, the duties are hazard identification, recognition, risk assessment, record keeping, responding to employee concerns, inspections, you inspect the building, and escalating issues to management, be it an inspection, an employee concern, a risk identification. The Occupational Health and Safety Acts regulate the formation, composition, how big is it, your committee, the training, the certification through WSIB, requirements for this committee members. So here's the numbers across Canadian jurisdictions. If you have 20 or more employees, you need to have a joint health and safety committee. If you have 10 or more in Newfoundland or Saskatchewan, again, you have to fill a committee. But in Ontario, it's 20 or more, and other provinces as well. In Quebec, workers can request a joint health and safety committee with written notice, more than 20 employees. Work refusals, you can refuse unsafe work. Every jurisdiction provides workers the right to refuse unsafe work without fear of reprisal, which means you can't be fired, you should not be fired. You should not be punished. You shouldn't get docked pay. That promotion that's coming up, that raise, that bonus, the employer cannot dangle any of that. Not dangle, but threaten rather. Can refuse work tasks if they have reasonable cause to believe the action would bring harm to themselves, but also to their peers, to others. Workers should follow established procedures to report a work refusal. So if anybody is working, please check to see if you have a work refusal. Limits. Essentially, a worker does not have the right to refuse unsafe work if It's normal working conditions, normal working practices. Um, um, understand that, let's say your job is Monday to Friday, 9 to 5, and the boss, let's say, asked you to come in early one day. You can't say that it's unsafe. So if the boss asks you to come in 8 in the morning, for instance, that is not an unsafe workplace. Some jurisdictions specify certain professions in its legislation on the limits in terms of that they can't refuse unsafe work. These professions include, and this is not exhaustive, and the context is Ontario, police officers, firefighters, and healthcare workers. So they cannot put through a right to refuse unsafe. It is part of their normal course of duty. Stop work provisions. Some jurisdictions have provisions to stop work in dangerous circumstances. Ontario legislation describes a dangerous circumstance as the following: a provision of the Act or the regulations being contravened. The contravention presents a danger. Sorry, I'm just trying to plug in the laptop. um, the contravention presents a danger or hazard to a worker or to a colleague. The danger or hazard is such that any delay in controlling this hazard could be serious endangerment of the worker, of any worker. That usually relates to fatalities or near misses. WHMIS, what is it? Why bother? Why is this interesting to you? Well, back in 1988, Workplace Hazardous Material Information System, also known as WHMIS, promoted workers' rights to know about chemical hazards in the workplace. It involved labels that alerts workers that a container contains inside it, no pun intended, a potentially hazard product. What was called material safety data sheets, now called safety data sheets, outlines a product's potential hazardous ingredients, safe handling procedures, but also first aid, also fire information as well. Also employee training. Now, there has been substantial changes to this legislation, this WHMIS legislation. It introduces new classes of chemicals. New chemicals are coming out every single day. Also new requirements for labels, as well as it's now called safety data sheet versus material safety data sheet. The WHMIS 2015, the latest changes to it incorporates elements of this GHS, which is globally harmonized system of classification and labeling of chemicals. GHS is an international standard and class of how to label, and it's adopted by countries around the world. So instead of it just being Canadian focused or North American focused, it is worldwide. GHS system elements are reflected in the WHMIS 2015, which helps ease global trade and business interaction. So WHMIS legislation, it focuses on chemicals, but also hazardous materials in the workplace. Think of asbestos. It enacts workers' rights to know about the hazards. So the employer has to inform this worker if they are handling any hazardous materials. Now, there has been a criminal code enacted that gives some teeth, some bite, some power to employees. And now what has changed is Bill C-45. It's also called West Ray legislation. It was passed in 2003 and then it became law in 2004. It's named after the West Ray mine tragedy. It holds executives, company executives, board of directors, president, CFO accountable when workers are killed, near misses, injured on the job as a result of management negligence. This criminal code of Canada means that executives, board of directors can get jail time. They can have a criminal record. Here is a protest, a social justice protest that We have no more deaths for mining, no more deaths in the workplace, no more West Rays. This outrage following the mining tragedy at West Ray helped prompt changes recognizing corporate criminal liability in the Criminal Code of Canada. So this is Canada-wide. This legislation makes the company responsible for the actions and deeds of those who oversee the day-to-day operations, the supervisor, the project manager, the mid-level manager, but also managers, both executive or operational, so the CEO, CTO, CFO, who intentionally commit or have employees commit crimes that benefits the organization. They're also held accountable. No shortcuts, basically, that could hurt people's lives. This legislation makes the company responsible for managers who do not take action when they become aware of offenses being committed, contraventions of the Act. The actions of managers who demonstrate a criminal lack of care. No due diligence is happening here. This is pure criminal negligence. Passing of the Bill C-45 into law meant the following. Here's two sections. Section 217, subsection 1. Those in authority for workers have a responsibility to take reasonable steps to protect those workers from harm. And sections 22.1 and 22.2, corporations can be criminally liable for negligence and other offenses. There have been several convictions happening, including large fines, prison times, as the example that I discussed. Environmental aspects, thinking about the transportation of dangerous goods, and it is intertwined with occupational health and safety. Our first week we talked about lac mécanique. Practitioners of health and safety need to be familiar with other legislations such as the Ontario Human Rights Code, environmental, transportation. So consider the following example. If a release of a hazardous substance occurs within a non-residential building, so think of an office tower, I guess, it falls under the jurisdiction of the authority enforcing the health and safety legislation. But if the release of this hazardous substance occurs outside the building, it falls under the jurisdiction and the authority that enforces environmental. So both authorities and sets of legislation may apply. You need to know these. It's beyond the scope of the code, the act. You also need to know the environmental as well as transport. I'll have you read this on your own. This is building awareness of the statutes relevant to Occupational Health and Safety Act in Canada. Just to list a few: Hazardous Products Act, Canadian Environmental Protection Act, Taking Care of Mother Earth, Canadian Charter of Rights and Freedoms, uber important to know. The code has followed and extrapolated from this charter. The Canada Labour Code, particularly if you're federal. Criminal Code of Canada, we talked about that just now. Pest Control Products Act, Transportation of Dangerous Goods Act, Radiation Emitting Devices Act, Canada Shipping Act, and Radiation Protection Regulations. When we talk about transportation of dangerous goods, it's the regulation of environmental hazards, occupational health and safety, and the transportation of dangerous goods. It is not the exclusive domain of the federal, provincial, or territorial governments. You need to be aware of these statutes, become familiar and relevant to their particular jurisdiction. Again, referring to lac mécanique. Environmental and transportation legislation seeks to supply the framework within society to protect itself from many risks that attends the transportation of inherently dangerous goods. I mean, dangerous goods are in railroads, vehicles, trucks on the highway, airplane, ships. Federal legislation governing the transportation of dangerous goods applies to all persons. I cannot emphasize this enough. All persons who handle, offer for transport, transport it itself, or import any dangerous goods. Here are some video links. They're relatively short. This one's a 3-minute one on health and safety in Canadian Workplaces Mental Health Commission of Canada, and then less than 2-minute one on basic worker rights. So the first one talks about standards, introduces a standard. This one talks about workers' rights. And this is the Young Workers' Right, CCOHS. All right, I think we're getting to our last. So for homework, review Module 3 and its contents. Please answer the discussion board as per the due date. Form groups of 4 to 5 on the discussion board by that due date. And please review other material. It is optional, but you may find some information that may help you from your group assignments, your discussion board, or just general interest. Please allow 2 days for announcements. They are pushed out from the Blackboard Ultra system via email. Thank you for joining me. I hope you found this was informational, and in gratitude for you attending classes and listening to these sessions. Cheers.